Like Singapore, a commercial dispute is resolved in 164 days, which is about 5 to 6 months. Similarly, in New Zealand, it takes about 216 days. UK, surprisingly, takes 437 days, which is about 14-15 months, which is still not that long compared to Pakistan. But considering it's the UK, you would expect them to do better. But still, I think their resolution disposal rate is pretty good. Now, specialized courts. What is the objective of setting up a specialized court? I mean, the obvious objective is that you have people with specialized knowledge, expertise, experience in a certain area to decide disputes of a certain type. Now, specialization has its own advantages. The advantage is, of course, if an expert judge who has experience in that area decides an issue, his approach, his perspective would be very different from a generalist judge. With due respect to the judges that we have pretty much around the world, they're called generalist judges because they can deal with a lot of matters within a certain area of law. So being a specialist judge, you have that advantage that you have a certain background in that particular area, which allows you to apply the law to the facts in a certain way, to use the evidence in a certain way, to arrive at a fair conclusion, which would be a lot better than what a generalist judge would do. So greater efficiency, you can decide cases quicker because you understand the issues better. So I'll give you the example. If you're a commercial court judge and you're deciding a dispute in the energy sector, unfortunately a lot of the judges who are generalist judges might not have that technical knowledge to understand unique issues of the energy sector. Same goes for telecom, electronics. You would have, or you should have, the edge in terms of that background knowledge, right? So knowledge is key, and I would urge you, of course you're all very respectable people and you know the law a lot more than I do, but I think as an approach I would urge you to keep reading up on relevant issues. So for instance, if you think in the first 6 months of your commercial judge position you are deciding a lot of energy sector issues, it is not sufficient just to read the file and understand the issues. To have a bigger picture, a broader perspective, you need to have knowledge outside of the file as well. Only then you'll be able to decide the cases better. So the industry knowledge, industry expertise is key. So that is something which is an ongoing process. You can't just say I read one book on commercial courts, I read one book on energy law. That is not sufficient because things are changing very rapidly all the time. You have to be up to date on all the developments. So that is one thing I would encourage you to do. Higher quality decisions. That is the expectation from a special commercial court judge, that generally and broadly speaking his or her decision in a commercial matter would be better than a generalist judge because, again, for the same reasons: more expertise, more experience, better understanding of the technical issues. Enhancing uniformity of decisions. Unfortunately, in common law jurisdictions, this is a problem not unique to Pakistan. It's true for the UK, the US as well. We lawyers complain about lack of authoritative judgments. We say, okay, on this issue we have one judgment, you'll find 2 judgments which are in complete contrast to this judgment. So one upside, one advantage of a commercial court judge and decisions coming out of those courts is that you can have authoritative and relatively more uniform and consistent judgments. Because again, because of your knowledge, because of your understanding, there will be less chance of contradictions in judgments passed by you and your learned brothers, right? And even your own judgment, let's say you decide the same issue 2-3 years later, there will be more consistency. And that is great for the jurisprudence in that particular area. Commercial law, again, is something very important. And if we have consistent, coherent jurisprudence, that helps the entire legal framework as well. And of course, the users of this service, the litigants who come to the courts, if they have an idea about the consistency of the decisions, they will have more faith. They will trust the system more. There will be more satisfaction. We talk about access to justice. Access to justice does not mean that you go to court and you get a decision. It doesn't just mean you get a fair decision. It means a decision which is reasoned, which is given by somebody who understands the issues well, right? So the users will be happy, you'll have better jurisprudence, and the entire system benefits from it. Now, potential disadvantages. So like anything in the world, there's no ideal solution or formula to dispute resolution. Anything that has advantages also has its share of disadvantages. So for commercial court judges, again, learn from the experience from around the world. One of the problems that they see with specialized court or let's say commercial court judges is that they have a very narrow perspective. So let's say you're a commercial court judge for 2 to 3 years and you only are hearing commercial cases, which is the way it's supposed to be. But after a while they think that you start thinking in a certain way, which has its own benefits, but then the downside is your perspective becomes narrow, and perhaps that affects the quality of your judgments also. So it's necessary, as I said, to know your industry, the area of law you're dealing with. At the same time, do not completely lose touch with other areas of law, because as you know way better than I do, law is an interplay of different areas of law. There are hardly any case in which only one area of law is done. There's always an interplay between 2, 3, 4 different areas. So I think one of the keys is, one of the things that we've learned from the global experiences is that you need to be up to date or connected to some other areas of law as well that are relevant for your judgments. Another sort of allegation or criticism is that when you are a commercial court judge, you deal with a certain type of lawyers. You have to decide cases of a certain type of parties, right? So commercial court judges, they have to deal with business disputes, companies, right? And company lawyers, although the number is growing, but it is not as large as, let's say, criminal lawyers or civil lawyers. So there's a specialized group of people who will be coming to your court, and it's human nature. We actually talk about it too, that familiarity is good to a certain extent, but after a while, too much familiarity has its disadvantages. So some people believe, one of the criticism is that if you are dealing with the same lawyers over and over again, there could be prejudice or bias in your decisions, because you've seen the same person a lot of times, and if, let's say, that person is a good lawyer, so you have this presumption in your head when they walk into the court that I think he will argue a good case, I think he has a strong case, I think I should decide in his favor. Nothing disrespectful to the judges, it's human nature, but they say that is also something we have to watch out for, because this prejudice, bias, if it comes in, it defeats the whole purpose. So again, that is one of the things we've learned from the global experiences. And then of course in other countries which are not that developed, there's cronyism, there's favoritism, nepotism. This is something that is exploited by some interest groups in societies as well. That is something specialized court judges have to be careful about. Risk of compartmentalization of judges' knowledge. Similar point that I raised earlier as well. Again, don't pigeonhole yourself, don't restrict yourself to one area. If, let's say, you have deciding commercial cases, again, keep in touch with other areas as well. So let's say if it's an energy sector dispute, intellectual property might be a relevant issue in that. If it's a telecom issue, knowledge of basic contracts, of course, that's true for all cases, that's important as well. So do not compartmentalize yourself, have a broad perspective. So another criticism is that there is a select group of judges who will be deciding commercial court matters, and because of a fewer number of people, the judgments are of a certain type, because they say that there is value in diversity. Let's say there are 10, 15 commercial court judges deciding certain commercial matters. Compare that to, let's say, 30 commercial court judges. What you will get from the commercial court judges with a larger number is possibly a better overarching legal framework or jurisprudence, because there are different people applying the law in different ways. So there's a richness to it. But again, you could also argue that if you have more judges, there could be more contradictions as well. So again, there's no ideal one right formula, but that is something you have to be mindful of, because you will be working together, you'll be perhaps discussing some issues as well, not specific to cases, but you have to be mindful that you don't sort of restrict yourself to a certain type of view or perspective. That is something that could affect the quality of your judgments. Undue power, I think this is a little unfair criticism. They say if there are, let's say, 10, 15 commercial court judges, they have undue power in deciding cases. By power, they don't mean any illegal power. What they mean is that you are concentrating commercial court judgments in the hands and minds of a few people, right? But if you go back to what I said at the outset, the benefit of specialization is you just allow a certain number of people to do it, but then the problem is if there's too much power, the laws start getting shaped in a certain way, right? So you have to be careful about that as well. Now, objective of commercial courts. So every country that has set up commercial courts, please go ahead. Right.
یہاں پہ یہ پورے یہ ورک ہم کو ایک خاص لیول تک وہ چیزوں کو ریلائز ہوں گے. تو یہی ٹائم جائیں گے ہائر کورس میں جائیں گے وہ تو اس پروسیس سے نہیں گزرے وہ کلیئر نہیں ہوئے ایکسپیرینس نہیں گزرے تو کیا ریزلٹس کرے گی.
That's a valid question. So my initial answer to this is that at the appellate level, I mean, so the merits aren't that important because the key issues have already been decided. And I think there is a presumption that a high court judge has a certain level of knowledge and experience. Again, it is not fair to generalize. I mean, there are better judges and they're not, so good judges. But I think that's the presumption. But I see your point. I agree with it, that the training does not have to stop at this level. But again, I'll be very honest with you. The senior the judge is, the higher the level is, the difficult it is to convince them to be trained. Again, it's not a problem unique to Pakistan, it's true for around the world. Very quickly, I once was discussing this with the United Nations official. I said that, how do we train judges, especially Superior Court judges? He said, the way we frame it is we don't call it training. We fly in judges from abroad and we say, let's have a round table discussion. You don't call it training. Nobody gets offended. They don't feel disrespected. They feel, we're having a roundtable discussion, but in the process, they're actually being trained. So it's how you frame it as well. Maybe at some point we'll have to do this in Pakistan. Again, it's not a suggestion, but I'm just saying. So, but I completely hear your point, because at some point, when inshallah you will start giving judgments, which will, let's say, be appealed, we need to have competent judges who understand the issues at least as well as you do. Preferably better than you do. Because they have bigger responsibility. They will either overturn your decision or uphold it. So I agree with you. But again, this is a start of the process. Hopefully, things will move in that direction as well. Any other questions? Feel free to interrupt me anytime. Okay, moving along. So the objectives are sometimes different. So let's say a country could set up commercial courts because they've passed a new law. And I think this is a controversial law. And because of that, there will be a lot of litigation. People will petition the courts, to exercise their rights. So a country says, okay, to deal with this, we'll set up courts that will deal exclusively with matters pertaining to this particular piece of legislation. So that could be one objective. That is not the case here. We've set it up. We already have the law. There's no new legislation as such. But the idea is to deal with commercial court cases. So in that particular case, the goal is to set it up for a short term, sometimes medium term, sometimes long term, right? Because if you think the response for that from that new litigation would be overwhelming in terms of more petitions in the courts, you'll say, okay, let's set up these courts for 2 years or 3 years. After that, things will settle down. We won't need these courts that much, and then we can move on. But in this case, as I understand it, and as done around the world generally, commercial courts once set up, it's not for a temporary purpose, it's for the long term. Which is good because it essentially means that you're dealing with commercial activities which don't really stop. As the economy grows, there's more economic activity, there's more disputes. So of course, you need more specialized courts. So in our case, it's not temporary. I understand it to be permanent. And of course, you have to deal with it accordingly. If a judge knows I've been appointed for a short time, these courts will disappear. In a couple of years, I think his or her approach will be different, as opposed to somebody who knows this is a permanent position or these courts will be around for a long time. Inconsistent judgment. So let's say litigants could complain. We go to courts. Let's say we go to civil court, district court, even high court, and judgments are inconsistent. They're contradictory judgments, and we need to have a forum, a specialized forum, which can avoid inconsistency. As I said at the start, uniformity, consistency is important. So in that case, it's helpful to have a specialized court to avoid any inconsistencies. I think I'm not sure how valid that reason is for our case, but to a certain extent, as a commercial lawyer myself, I think there are inconsistencies sometimes, and because of the commercial courts, hopefully we'll be able to avoid that as well. Moving on. So backlog of cases, of course, that's sort of a very old problem we have had, and the argument basically is, around the world also, commercial courts are set up for the expeditious resolution of disputes because the economy depends on it. People could ask, people could say, why are commercial cases so important? Why aren't family cases as important or other civil cases? Why are they being given priority? I would argue that your economy depends on quick resolution of disputes. Foreign investors go to countries where the judicial system is functional, it's effective. That's a big consideration. I mean, generally there is no direct correlation, but a lot of foreign investors consider this when they go to a country. They look at how effective the system is. So if commercial courts are functioning well, that will help foreign investment, that will help economic activity in the country as well. So it's important in that sense, and that will deal with the backlog of cases. If a foreign investor knows I go to Pakistan, and of course if there is no arbitration clause, I have to go before local courts, and they know the local courts will not decide the case for at least 3 years, going by the World Bank metrics, this will discourage them from investing in Pakistan, as opposed to a foreign investor thinking, oh, Pakistan, by the way, they have commercial courts, and commercial courts are deciding cases in 6 months, 3 months, even 1 year. More importantly, there are always two components. It's not how quickly you give the decision, it's the quality of the decision. So a litigant could say, oh, I just want the decision in 3 months, but if unfortunately the decision doesn't have any valid reasoning, it's not a fair decision, defeats the purpose. Same goes for a good decision given very late. Good decision come after 4 years, like what's the point? So there has to be a balance between the two. You have to make sure quality decisions and prompt decisions. So there are different models of judicial specialization. I won't go into the details. So around the world, since we're talking about global experiences, different models are set up. So in some countries, they set up exclusive commercial courts. They have a separate building, separate registry, separate administrative services. Staff is separate. Then of course there's the concept of having a bench, and then of course there's something called an ad hoc panel. So whereby there's this implicit understanding that a certain type of cases will be assigned to certain type of judges. There is no formal mechanism, but informally. So there's different judicial models, but in our case, my understanding is it is basically will work like a division or a bench of the court, which helps us because we don't have to pass new legislation. So once this thing becomes successful, even if you have to pass legislation, it will be easier to show the lawmakers that this has gone very well. We need to formalize this mechanism by setting up courts in a different manner. I'll talk briefly about English commercial court. Everybody talks about it. They think this is one of the most important courts in the world. And one of the reasons why the English commercial court is so important is not that it's very old, but it's because a lot of the international commercial and business disputes stipulate that the governing law of the contract will be English law. So you have a commercial contract, parties say this contract will be governed by English law. So let's say one party is from Pakistan, one is from Germany. The German party will not agree on Pakistani law, Pakistani party will not agree on German law. They decide, okay, let's go for a neutral law which has good developed jurisprudence. English law is one of them. You could have New York law, even French laws in some cases. So because of that, a lot of the matters end up before English commercial courts. And of course, they've been doing it for a long time. And of course, they deal with both domestic and international disputes. So the English commercial court is not, technically speaking, an international commercial court. It's essentially a domestic court which also deals with international matters. So their jurisdiction basically is over disputes that have a connection with the UK. So the parties are residents, let's say companies that are incorporated in the UK, or if the parties have done some part of the business in the UK, so there is a nexus with the jurisdiction, and then they decide that dispute. Arbitration actually takes up about 30% of their caseload. So by arbitration, the types of disputes that would go before the English commercial courts would be, I want to enforce the arbitration agreement or agreement in which English law is the governing law. A party could also go to UK commercial court if they want to challenge the validity of the arbitration award, arbitration agreement. They could say this was not a valid agreement, this was not entered into with our consent, therefore this agreement should be declared invalid and we cannot arbitrate. Then they would go to English commercial court. If an arbitration proceedings have been completed, you have an award, arbitral award. If a party wants to challenge it, they would also go to the English commercial court if the law is English commercial law, and especially if the seat of arbitration is the UK. So in all those cases, they have to deal with a lot of arbitration matters, and they end up being international for the most part. And so their jurisdiction essentially relates to Challenges to awards, appeal on a point of law. So for those of you familiar again with arbitration, one of the benefits of arbitration is that there is no appeal of the award. It's final and binding. Of course, there are certain grounds on the basis of which you can challenge the award, technical grounds, arbitrator misconduct, lack of due process of law and all those. But the UK commercial courts are different in the sense that they, I believe, are either the only one or one of the very few commercial courts around the world that have jurisdiction to even set aside an award, arbitral award, on the basis of a point of law. Generally, courts, whether it's commercial court or civil court, they're not supposed to go behind the award to set it aside, but English commercial courts have that power as well, which I think is a very broad power. Injunctions enforcement, of course, the parties go to English commercial courts to seek a stay order, injunctive relief, for preservation of assets, even for appointment of an arbitrator. Just the way parties go to civil court here to appoint an arbitrator if there is no agreement, the UK commercial courts perform that function as well. Some of the complex disputes that they are involved with or decide are disputes over contracts, business documents, insurance and reinsurance, sale of commodities, import-export. So there's a wide variety of cases. So another code I want to talk about, since we're discussing global experiences, is one code in the US. It's called the Delaware Court of Chancery. So Chancery is a word, comes from chancellor. So back in the day, in the old days, the king used to make the laws 300-400 years ago, and the chancellor was the one who used to decide disputes. So basically the legacy has continued, and in the US, Delaware, I believe this court was set up about 300 years ago. It's one of the oldest courts. And a large number of companies around the world, even Pakistanis, if they want to register a company in the US, they would register it in Delaware. Delaware is a state in the US which is known for its company incorporation. And one of the main reasons why parties register their companies in Delaware is because of this court. This court has a lot of trust and it has a very good reputation. So this court essentially works like a business/commercial court, and one chancellor, essentially like a judge, will hear the case and decide. There is no bench as such. Of course, they're skilled and trained in corporate law, commercial law, and there is no requirement of a jury, because in the US there is a jury requirement for a lot of the proceedings. There is no such requirement either. Let me talk about some of the underwhelming experiences, some of the cases or countries in which this commercial court did not go very well. So there's one example of Tanzania, a country in Africa. So about 20 years ago, they set up these specialized commercial courts there. And the idea basically was to facilitate business transactions and all that. But unfortunately, what happened was, even after setting up the commercial courts, the economic activity or foreign investment coming into Tanzania did not change. And people were curious, what happened? We set up the commercial courts, it's good for the economy, foreign investors will come in. I said the problem was that considering the state of Tanzania, they did not care about the courts or their existence. It did not matter to them whether the courts were commercial courts or regular courts, because the way they did business, they did not follow the law. So if they did not follow the law, they did not care about going to court or responding to a petition or a plaint filed against them. So you cannot generalize. Just because you've set up a commercial court does not necessarily mean that your economy will take off and become a fast growing economy. Unfortunately, that is not the case. There are a lot of other things at work as well. But commercial court judges still have a very important role to play. Whatever little cases, matters come to you, if they're decided effectively and decisions are of quality, it helps the country's reputation, right? So we're not expecting miracles overnight. We're expecting even small change. You start with a small change and then you move on. But so Tanzania, the experience wasn't good. Another is Peru in Latin America, South America. In 2005, they set up these specialized courts. And in the first year, they did very well. The case disposal was very good. The quality of the decisions was very good. The government was very happy. And as a result, what they did was, they increased their caseload by 11 times. So let's say they were deciding 1,000 cases in 1 year. The government expected them to decide 11,000 cases. And not surprisingly, what happened was the quality of the judgments went down, case disposal rate got worse, so it backfired. So the expression for that is being a victim of your own success. You're so successful that you eventually become a victim of it. So you have to strike that balance. Again, I'm not suggesting that you should have a certain caseload. Of course, that is something to be decided in due course. But I think if you are overburdened with a certain number of cases, and the expectation is, you're a specialized court, you should be able to deal with it. I think that would be an unfair expectation. So that's one of the things we've learned from the experience in Peru, that I think you should start slow, because everybody, you need some time to acquaint yourself, with relevant laws, procedures, and you cannot expect, let's say after the first year, second year, that you're burdened with so many cases that it becomes just unsustainable. So that's one of the things we've learned from the experience in Peru. Cross-border transactions, I've referred to international disputes. So what happens is, when a foreign investor comes to Pakistan, let's say there's a Chinese company coming to Pakistan, they invest in Pakistan. Any investor who comes into Pakistan does not trust the local courts. Why would they trust? If you go invest in China, Germany, England, America, you will not trust. By trust, I don't mean that the courts are not functioning properly. What I mean is, you would prefer your own local court. You don't know the system that well, right? There's this uncertainty. So that is why a lot of the foreign investors, businesses, international, they choose international arbitration, whereby there's a neutral forum, there'll be neutral arbitrator, generally of a neutral nationality. The arbitration proceedings will be conducted in a neutral country. The governing law could be of a neutral country. So you can play around. There's a lot of procedural flexibility. You can pick your own law, you can pick your own arbitrator, you can pick your seat, governing law. So you have a lot of choices, which is why international arbitration has been very successful for resolution of commercial disputes. But the states, they get involved as well. So the recent trend, the past 10-15 years, has been the rise of international commercial courts. And the idea basically is to provide a combination of arbitration and litigation, to provide the best of both. So the users, the parties who go to them, get the benefits of both litigation and arbitration. So there are several examples. Dubai International Financial Center has its own DIFC court. Abu Dhabi has this global market courts, EDGM. Qatar has one. It's called Qatar International Court and Dispute Resolution Center. Singapore, they set it up about 5 years ago, Singapore International Commercial Court. I think most recently Astana in Kazakhstan, they have set up an international financial center, and so there is a court there as well. They have launched it. And then of course China International Commercial Court. China launched its commercial court about 2 years ago as well, and with one seat in the city called Shenzhen, one in Xi'an. Now again, from a standpoint of commercial dispute resolution, what is the benefit of international commercial courts? State has some control because it's a court. It's not a private dispute resolution mechanism like arbitration. So the positive is that when the commercial court gives a decision, of course it is binding like an award, but the enforcement is easier as well because it's a court decision. One of the problems with the arbitration proceedings is that the arbitrator or the tribunal does not have coercive power. By coercive power, I mean, if you go to the arbitrator, say, sir or madam, please pass an injunction. We think that while we arbitrate the dispute, this party will dispose of its assets. The arbitrator will say, I will be happy to give directions, but you cannot have them enforced until you go to the local court, right? So that's a disadvantage, especially if the matter is urgent. International commercial court solves that problem. They give you that advantage that if you want, let's say, injunctive relief, you want it quickly, you can get it from the same forum. You don't have to go to a different court to get that relief. So that's one advantage. Although for arbitration is considered very quick, very cheap, international arbitration unfortunately sometimes drags on for a long time, 2-3 years, and it costs a lot of money as well, because the stakes are very high. So the parties do spend a lot of time and money to resolve the dispute. So one of the criticisms of international arbitration is that it is not really that cost efficient or time efficient. So international commercial courts can deal with that issue better as well by having stricter, tighter deadlines for matters. So that's one thing, and of course they can save money as well. Another downside to arbitration is joinder of third parties. It's very easy. You do this all the time, I'm sure. You can join third parties to the proceeding. You cannot do that in arbitration because the fundamental principle of arbitration is mutual consent. Arbitration is a creature of the contract. If a party has not consented to that particular clause agreement, you cannot force that party to arbitrate. But in the case of litigation, court proceeding, you can file an application and implead a third party and join them. So in some international arbitration cases, this becomes a big problem. Two parties enter into an agreement, but there's an important third party. It could be a vendor, could be another business partner who did not sign that agreement, but it is very important for both the parties to have that third party join the proceedings. But you can't do anything about it. It's very difficult. International Commercial Court solves that problem as well. So it will give you that option of joinder as well. Lack of consistency. So one of the criticisms of arbitration is it's confidential, which is again a benefit. Why do people arbitrate? They arbitrate because they want to keep their company's information, disputes confidential. Big businesses, reputable businesses don't want mudslinging in the public. Any self-respecting, honorable businessman or business would not want their reputation to be dragged in mud in public, right? Which unfortunately happens in court proceedings. So they pick arbitration. They say this is confidential. Whatever allegation is against us, whatever amounts are involved, we don't want the public to find out. International commercial courts don't give you that option because it's a public forum. It's a court. It cannot be confidential. So arbitration has that advantage, but sometimes it becomes a disadvantage as well. And so international commercial courts, it's basically give and take. You have to sacrifice some of the benefits to get some other benefits. So if you want, let's say, to join third parties, you will have to give up confidentiality. If you want confidentiality, you will have to give that. So it's always a trade-off. But I think the countries launching international commercial courts believe that they've offered the best of both. So that's another area they focus on. Absence of appeals. So this is one of the advantages, so to speak, that just the way an arbitral award is final and binding, just because you go to international commercial court doesn't mean that you can keep going on. But international commercial courts do have this option of appeals in some cases. So let's say you think the dispute involves $20 million and you have faith in the arbitrator or the tribunal, yet when the decision comes, you think there are some defects in the judgment. Now you cannot appeal that award. You can of course challenge it in the relevant jurisdiction. If let's say you're arbitrating in London, the seat of arbitration is London, you can go to a local London court, most likely the English Commercial Court, and file a petition for setting aside the award because of some defects in it. But generally speaking, you cannot appeal it on the merits. So when international commercial court, what they offer to parties is you can arbitrate a dispute, but then you join the benefits of both, and you can also appeal that particular commercial court decision. So all of those people who are very concerned or paranoid about arbitration not have an appellate mechanism are actually happy about this, that international commercial courts offer them that option. Now, so again, as I said, every forum, every commercial dispute resolution mechanism has its advantages, disadvantages. One of the disadvantages of international commercial courts is lack of procedural flexibility. Of course, as judges, you do this every day, the procedure is set. There is no flexibility as such, right? You follow the civil procedure code or whatever relevant rules and regulations. In arbitration, you design your own procedure. You say, we will arbitrate under the rules of this institution, or we will choose ad hoc arbitration. We will not follow the rules of any institution. We will come up with our own rules. So you have flexibility. So let's say you want to say, we will have witness statements in writing. You can have that. We will not have any examination in chief orally. We'll have the witness statement in writing. You can do that. You can say that no party can submit a claim which is longer than 10 pages. No party can have more than 2 witnesses. You can do all that because parties can mutually agree on this. So you have flexibility, which is one of the things people appreciate. This is something you don't get in an international commercial court because it's a court. It has a certain set of rules that you have to follow strictly. There is no flexibility. But for those who prefer going to a court, they appreciate this benefit. And no confidentiality. So all those parties who value confidentiality, that's one of the things they have to give up. It will be public forum. The whole world will know about it, because it's not even a domestic commercial code. It's an international commercial code, which is, at this point, they're not very busy. They're not deciding many cases. So DIFC LCA is one of the DIFC courts. They are one of those few courts which are fairly busy. I think Singapore National Commercial Court too, but the others sort of are catching up. So the very few cases that do end up before those courts, people find out about them. It's not for the masses, but people in the relevant industry. So let's say it's a dispute regarding a telecom company. Most telecom companies around the world will learn about them. Energy company, they'll find out. So there's no confidentiality. You have to be mindful of that as well. And of course the right to appeal, that you have to give as well. So a bit about the Singapore National Commercial Code. So one of the reasons why